All right, so welcome to today's webinar, What to Do If You're the Victim of Domestic Violence. Obviously not the best topic or the most enjoyable to talk about, but certainly very important to many people. Give you a little explanation of how today's webinar is going to run, as well as most webinars if you attend any in the future. Um, it's intended to be 45 minutes long. It will sometimes be a little longer, sometimes be a little shorter. Um, I do stay as long as it takes to get through the information. It's, as you can probably tell by now, it's a one-way communication, so you can hear me, I can hear you. But there is a pane where you were typing in before to ask questions. I will stay afterwards to answer any questions that are presented, and if there's any additional information that's needed to figure out how to get that to you in the future. So, as I said, the title of this webinar is What to Do If You're the Victim of Domestic Violence. The intention of today's webinar is probably threefold. One is to inform people what is domestic violence, why we have these laws, how they're supposed to operate, give a little practical insight to what to do if you are a victim or if you know somebody who is a victim, and also, probably most importantly, to address what problems and issues will arise in more the legal system aspect than in the personal life that one deals with in these kinds of situations. It's not always, unfortunately, as smooth as you would hope, and it's good to know how to navigate these sensitive issues beforehand. Let me give you a little background about me. I am the managing member of the Micklin Law Firm. I've been practicing law now for about a little shy of 20 years, I think about 18 or 19 years now. I am licensed in both New Jersey and Pennsylvania, as well as the Third Federal District Court. I came out of law school and I started my career as a judicial law clerk, which means I worked for a judge. It was the supervising judge of special civil litigation in Bergen County. So I spent the year sort of working behind the scenes, learning what judges do with your papers, what they do and don't like in a court case. From there, I went to Kessler and Associates. And I did complex commercial litigation for a couple of years. Found that I didn't care much for representing businesses. I liked dealing with people, so I transitioned to my own law firm in 2001. My areas of practice at that time, I was a general practitioner, but around 2002 or three, I started to focus my practice into divorce, family law, and estate planning and litigation, which is where it is now. I formed the Micklin Law Group around 2010. I hired a few associates, client service managers, some administrative staff. The purpose of forming the group was I wanted to ensure to have the resources necessary to do complex litigation work, but not to have to be part of a large firm where I once again didn't have contact with my clients or with individuals. The Micklin Law Group is also concentrated in divorce, family law, and estate planning and litigation. I do more of the complex commercial and divorce litigations as well as the estate planning and probate litigation. All right, so let's jump right into some of the information here. How and why did the restraining order laws come into place? So here I list many of the most significant reasons, the legislative findings, which were that one, domestic violence is and was at the time of the passing of the statute a very serious crime against society as a whole. A lot of people view domestic violence as a person-to-person victim, but there are many people who are affected by domestic violence. At the time these laws started to originate around the early 70s, the legislature found that there were a significant number of women, pregnant women, who were victims. That's not to say that at the time there were not other victims. Obviously, at that time and now, there are elderly were victims, disabled people, men, minors were also victims. But at the time that they started to investigate these issues, and more nationwide, not just in New Jersey, the significant number of victims were women, often pregnant women, and that still exists today. That still would be the largest group of victims. The findings that it crossed all social and economic backgrounds, so it didn't matter what your race or religion was, it didn't matter your economic standard or your socioeconomic class, you could still be considered a victim. There's many, many different types of domestic violence, as we'll see, and it transgresses through all types of people, unfortunately. There was also a finding that there's a significant correlation between spousal and child abuse. One, in that even if the child itself is not being abused in a relationship, but if a parent is being abused, that child is a victim. The child is being harmed by being subject to watching a parent be abused. Also, if that child is a victim of a domestic violence relationship, that child often grows up to repeat the conduct, so it becomes a secular pattern in families. And the most important reason, not to indicate by being last, but it is the most important, was the issues of domestic violence were not being treated seriously by law enforcement and even the courts. Basically, if you were to walk out in the street and strike somebody, you get arrested and prosecuted without question. But back in, again, the early 70s, and even sometimes today, if you go home and strike your spouse, you're not necessarily prosecuted in the same way. So they needed to create a system that would be an automatic system to protect these victims, and it originated to remove the discretion from the police officers, the law enforcement, and even the judiciary, so that they had no discretion but to be involved. So who's protected under the statute? Okay, first, any 18-year-old older or emancipated minor who has been subjected to domestic violence by a spouse, former spouse, or household member. That's the first class of individuals who are protected. And the significant part at the time was a household member, so that it didn't have to necessarily be an intimate partner of any sort. Second was anyone who has been subject to domestic violence by a person with whom the victim either has a child or with whom the victim anticipates having a child, or if one of the parties is pregnant. Again, this came out of the legislative finding that a lot of victims were women, and often pregnant women. Here you notice the difference between the first and the second, obviously, is being the victim is pregnant or anticipates having a child, but it also says it's with a person as opposed to a spouse or household member, which is part of the 18 years older or above. The difference is because of same-sex relationships or adoptive relationships, you may not necessarily be a household member or even a spouse, but you may be sharing a child in common. So the second portion was to cover that unique class of people. And then the last was, or is, the victim has been subject to domestic violence by a person with whom they have or had a dating relationship. Again, that's a broader sense intended to give a greater umbrella of protection to individuals who may not necessarily fall into the first two. So what these three different paragraphs, and I summarized them here, but I read them at greater length, is they're trying to cover all facets of relationships that they anticipated would commonly have domestic violence aspects. What we find now is that the case law has been actually even greatly increasing the protected class of individuals under the domestic violence statute. The case law now allows, in some cases, simple roommate relationships, parent-child relationships, and there's a growing increase to protect more and more people. The intention of the act itself being to protect victims of domestic violence, so they want to try to encompass as many individuals as they can. The basis for determining whether or not a person is a protected member that may not fall under these three groups is if the relationship itself is what leads to allowing a person to victimize or abuse the other person. The nature of their relationship, either past or present, is what creates the forum that they're able to abuse the other individual. Then they would be considered a protected class. And like I said, I think over the next few years, we're going to see that class even expand beyond what we have now. So what are the acts of domestic violence that fall under the statute? Because in order to be protected by either a temporary or a final order, the judge has to find that an act of domestic violence has occurred. In order to create or list the acts, what the legislature did was to track the criminal statute with certain criminal acts that, if committed against the protected classes I just mentioned, would fall under the need for protection. Now, I'm going to read them in different orders. The line of the list on the right: lewdness, criminal mischief, burglary, criminal trespass, harassment, and stalking. Those are the most common that we see, and largely because, in a sort of sense, they're uh, more benign than the list on the right, which is homicide, assault, terroristic threats, kidnapping, criminal restraint, false imprisonment, sexual assault, criminal sexual conduct. Not to say that these don't occur and these are not bases to file a restraining order, but the most common you will see are the lists on the right. Um, Partially because they're more common and because they're more benign, that more people will actually commit them and not realize that they are committing violence. Um, Now, the last three, even though being the most common of this list, are also the most difficult to establish because they all require an intent. Criminal trespass is an intent to trespass. Harassment is an intent to harass, and same with stalking. Many people, for instance, with harassment, which is obviously the most common domestic violence act alleged, it's hard to establish the intent to harass. Many people may say or claim or actually intend a different meaning behind an abusive act, which eliminates the fact that it is abusive, but yet the victim is still victimized by it. So it's a very fine line to prove intention to commit one of these acts, at least on the right side. Obviously, the ones on the left are clear without any kind of issue. So let's look at the process of obtaining a restraining order. Now, this is really applicable to a temporary restraining order. So first is Monday through Friday between 8:30 and 4 o'clock. And this means that this is either when the act occurs or when you are choosing to go and seek the protection of a restraining order. Now, usually, or often, I should say, they are at roughly the same time. Not necessarily. Some people do tend to wait a period of time. But if you are going or the act occurs between 8:30 and 4:30 Monday or Friday, then you would go to the domestic violence unit of your local county courthouse. There are domestic violence units. When you check into any courthouse, you can explain to them the nature of the reason you're there. They'll direct you and maybe even escort you to the unit room so that you can be held right away. They will bring you sometimes to a judge, sometimes to a domestic violence hearing officer, which is usually a local attorney that they bring in. You will fill out the forms. Sometimes you are brought before a judge to actually testify. Sometimes the judge just reads the papers and decides whether or not to grant the temporary order. Most of the time, I should say, they do give out temporary orders, even in cases where it seems sort of clear that it may not be the intended protection, but they still grant them. Usually it's safer to err on the side of caution than to dismiss them. Now, you may run into an issue sometimes when you go to the county court where I usually recommend you go to where either you reside or where the act occurred. And more often than not, it should be where the act occurred. But you may go and explain in your county courthouse of your residence, and they may tell you you need to go somewhere else. But go, I guess, to the one that's probably the most convenient so you can get there quickly and make sure to take care of it. And if you are in the wrong courthouse, they'll simply redirect you to where the next best place to go would be. Evening, weekends, and holidays. Actually, any time basically the courthouses are closed, which is usually evening, weekends, and holidays. You go to the local police department, you'll fill out the paperwork there, and they will either usually not bring you to, but they'll get a judge on the phone who is usually a municipal court judge, which is a lower level court system beneath the trial court system. But there is an emergent duty judge on call in New Jersey 24 hours a day, 7 days a week. So at any time that you feel the need to get protection, there is somebody available. One of the things I caution about, and this goes back to the legislative intent where they indicated that law enforcement weren't really helpful in many circumstances, you will often incur some opposition when you go to file restraining orders at late hours or on holidays because, one, sometimes police don't want to be involved. Two, they don't necessarily want to wake the judge up. but these matters are far too important to be discouraged by that kind of, I'm going to call it ignorance. Um, you need to sort of just charge through it. You have an absolute right to appear at those times. There is a reason why there are judges on duty 24 hours a day, 7 days a week. So don't be discouraged and dissuaded from utilizing it. Now, you'll get a temporary restraining order usually issued right immediately after your testimony, right after the judge reviews it. And the reason the temporary orders will often give very quick, immediate relief, and we'll go through the specifics later. But because of what it tends to grant and the changes that it makes in both the victims and the perpetrators' lives, they will order a hearing to be promptly, and it's usually within 10 days. But I tell most people, when you go to fill out the temporary order, and we'll go through some information later about what to do with that, expect that it's going to be more than 10 days, even though they schedule it for 10 days. There are often very significant delays, either between attorneys getting involved, court schedules, your schedules. I've seen often it can take another 30 days before you're actually heard. So whether you're the, let's say, the alleged victim or the alleged perpetrator, you may be out of court and under the protection of this order for many, many weeks. So things that you need to keep in mind later when we talk about the types of relief to ask for when filling out a temporary restraining order. So let's talk about what you do to fill out the temporary restraining order. And we're going to go through in a second. I'm actually going to walk you through the forms and tell you certain places that are really important to watch out. But first of all, you need to list all the factual details. And I'll show you in the form how that is and where there's issues about it. If you forget something, you must notify the court immediately. There are, I think, uniformly processes to amend the restraining order. But if you don't amend it, it's not going to be included. So if anything comes up, then you must notify them immediately and find out how to amend it, to correct it. They will ask about criminal history and weapon use. It's very important that if you're not sure about this, that you include it. Better to be incorrect about some information than to leave out something like that there's criminal history or that there's weapons, because they will seize any weapons. So if you think there's something, you should definitely include it. List all previous acts of domestic violence and abuse, and I'll show you in the form where that is. Very, very important. Crucial. Also, check all the boxes for relief sought. Again, I'll show you in a minute where that is. I list some of them here, which we'll see: seizure of weapons, prohibiting contact with you, children, relatives, employers, friends, anybody that you think is sort of somebody that you need to keep that person away from also. Prohibition about entering the specific locations, like family's house, relative's house, employment locations, sole possession of the house, at least temporarily, custody, possibly sole custody of the children, restriction of parenting time, financial support, possession of vehicles. I also have items and documents. You may want to get personal items back, like laptop computers, car keys, Social Security documents. You can ask for risk assessments, drug or alcohol evaluations, psychological evaluations and reports, compensation for losses, pain and suffering damages. It's a very long list that you can get. It's sometimes helpful if you have time to contemplate before you're going for a restraining order to seek advice about what relief you may need. Again, I don't usually recommend people delay from the time an act occurs to the time they seek a restraining order, but if there's going to be delay, it might be good to talk to somebody about what relief you're going to need. Lawyers who are involved in this type of work often may know better than you what you're going to run into. So it's good to know that before you actually find yourself in that circumstance. So let's take a look at the forms. I have here, I redacted one of our client's forms to go through some important parts. I'm going to try to use this little pen here, but it actually just disappeared on me. Not really the best with it, but okay, so up here, this is all basic information. It's blacked out so that you don't know whose form this was, but this will all be filled in by the police or the court, whichever system you go to. So the most important part to look at first is right here, this section right here. This is where they will type in the act or acts that you allege occurred. Now, there's many things that are important about this section. First, in order to get an order entered, you have to establish that an act of domestic violence occurred, and that's the list that we indicated before. But not every single act warrants the entry of a restraining order if it occurs maybe one time. But there could be a course of conduct that does. So don't be led to believe that the information that you put into here, the act of domestic, has to be limited to one day. You can put a 30-day window. You can put a 12-month window of what was occurring in here, and have it be considered the one single act of domestic violence, which will greatly increase your ability of getting a restraining order. Now, the problems that you'll run into here, one is space. Now, they can add space to these lists, but you will often find that people that are filling these forms out for you, police as well as in the court system, do not fill them out right. Even if you will give them 3 different dates and they'll only put the first date in here. And I'll show you later where they're putting the rest. And you have to insist that all of the acts you allege go into this one. Because if you have one act here and then 4 in the past, if the one act that you allege is not sufficient, you're not going to get the restraining order. So if there's anybody that's listening to this or listens in the future to this that may find themselves getting a restraining order in the future, you should be taking notes about this section because it's very important. You have to insist that they write into this section exactly what you want them to write, whether it's several acts, regardless of what they tell you it means. If they tell you that you're incorrect, it doesn't matter. You have to insist upon it. It will make or break getting the restraining order. Also, when you think of something that you forgot, like I said before, and you notify them and you amend it, you want to amend it and insist that it goes into here. I've had cases where they've refused to do that for my clients, and I've actually sent a letter to the court documenting and confirming that while they filled it out this way, it's our intention that we're testifying as the continuing act of domestic violence. Now, the next section here is more often than not going to also be filled out by them, and this is the act of domestic violence, like we were talking about the list, from homicide to assault all the way down to harassment and stalking. Use some caution here. Don't just check everything. Obviously, things that aren't going to apply. If you're in doubt about something here, it's probably usually safer to put it in than to leave it out, because you could deal with it by explaining later that you weren't clear about it, but it's harder to add something in. It's hard generally to add something in when you go to court that you didn't put into this form. Now next, and this is the most important here, question number 1 is if there's a history of domestic violence, either reported or unreported. Now, this is a very significant section for many, many reasons. First, if the court considers that there is an act of domestic violence by what you read in here, they are required to then look at the history of domestic violence. One of the biggest problems I find in here, people often confuse themselves of what is and is not domestic violence. People seem to believe that if it wasn't filed, it's not an act of domestic violence. If there wasn't a restraining order, it doesn't matter. There's no legal standard here. It's not a question of, did you go to court? Was there a police reporter involved? If there was an act committed that you feel was an act of domestic violence, it goes in here. If somebody yelled at you, if they threw the telephone, if they blocked your car from leaving the driveway, if they kept your child from you, that goes into here with as much data and specifics as you can. And again, you'll find some opposition when you want to go into a history when you're filling these forms out, that people will resist actually putting in your information. You have to insist that the information go into this. If not, you have to amend it later, or you have to write to the court about what and why it was left out to ensure that they know it should have been in there. So again, these 2 portions are the most important to get everything in there. If you don't have information in one of these 2 sections, the court will not allow you to testify. Well, I should change that. They will allow you, but the only way to do it is if they adjourn the hearing, have you amend it, and then you come back another day, which means everything is elongated, as well as the perpetrator has also heard most of your testimony and has a lot more time to prepare. So when you go to court, you want to just go this one time. Turning quickly over to here, this whole section again is this is TRO, FRO, requested relief, and then here is granted. So obviously you're going to have them, I think it's them, I don't think it'd be you, fill out all of these that you're going to want them to enter. And don't be shy about what you want them to grant you, because it may not be granted. It's up to the court to decide whether or not to grant it, but you should be requesting it. Especially also down here, the list continues. Right here where it says other relief, this is where you want to have them indicate what kind of monetary relief you may be seeking. Payment of rent or mortgage, car payments, child support, money for food. Again, anticipate that you may not and you are not likely to be heard in the 10 days that they promise, and expect delays. So contemplate what you're going to need provided for you during this time. Okay, moving to the next page of the form, going down to this bottom part here, again with the list that I talked about. Oh, sorry. Before, here is personal property. Again, think about what you're going to need: laptop computers, car keys, birth certificates, social security cards, plane tickets, whatever it may be. Ask for it. Make sure that it's put here, because if it's not, you're not going to get it quickly. And if you're dealing with, obviously, an abuser, they may use that as a form of control to not give it to you. So whatever is going to be necessary, you have to list it here. So again, sometimes it is good to take a moment or two before seeking the protections or restraining order to really think it through and talk to somebody to make sure that it's done right, but never delay too much. All right, so let's look at the difference between a temporary and a final restraining order. All right, so first, a temporary order is granted on what's called an ex parte basis. So that means that the defendant is not present, does not have to be present, and will not even usually know that you're seeking it. It's going to be based on the victim's testimony alone, and the order is temporary until the final hearing occurs. Now, sometimes a final hearing occurs and doesn't actually conclude the same day, so your temporary will be continued. If you go and have a case that's going to be adjourned and moved to another day, again, the temporary order will continue in place until the final order is actually granted. There will never be a lapse of protection between the first and the second, no matter how much time is in between the two. The FRO is permanent, doesn't expire without consent or court order. Some jurisdictions have it where a restraining order, a final restraining order, is for a specific duration. New Jersey at least claims that it's permanent. There are, and we'll talk about this, I think, in a few slides. There are some bases to seek to dissolve it, but essentially it's intended to be permanent. The final is only issued after a hearing and the judge finds these two things: one, an act of domestic violence occurred, which is why I was showing you the form, and two, that a final order is necessary to prevent future abuse. And this is an important distinction, because while there may be an act of domestic violence, it doesn't necessarily mean that everybody needs to be protected permanently. There's a legal theory called domestic contretemps, which basically says people fight. And just because they fight and it may get out of hand, people may do things that are inappropriate and maybe even unlawful, doesn't necessarily mean that a domestic violence protection order should issue for permanent protection. And it's a very fine analysis that the judge is required to make before issuing the final. And also at the final, if you're the defendant, well, actually both sides, but considering that the temporary is granted without the defendant at a final gets to cross-examine the victim and the victim's witnesses, and can also testify and call his or her own witnesses and testify. The victim is granted an opportunity also to cross-examine. But the thing to remember here is, if you are the victim, there is going to be an opportunity for the defendant to question you on the stand about your allegations. Now, if you and he or she are unrepresented, it's sometimes a daunting task. Now, courts will generally be very careful in limiting the conduct of the domestic violence perpetrator, so that he or she can't use the court as a forum to harass or the questions. But it's a fine line. It's going to be troubling just to be questioned in the first place by a person who has abused you. So you may need to have a little, or you maybe want to get a little counseling before going into that, if you're going to do this without an attorney. So what are some of the forms of relief in a final order? What we talked about before was what you can ask for in a temporary, which isn't much different. It's not really much limited, but usually you're going to want more expansive relief in a final order because it's going to be final. It's going to create a relationship where there's not going to be, or likely not to be, any contact between the two individuals. So you need to continue whatever needs to be ordered so that your life is not interrupted by this order. So firstly, obviously, the order will always say the protection from future acts of violence and prohibition against any contact or harassment. But moreover, it will also generally give custody of minor children, and it carries a presumption of sole custody because of the inability with a restraining order to communicate it, as well as the unequal sort of bargaining position that a victim stands in when dealing with his or her abuser. It should, and more often will, contain support or house expenses, we usually call roof expenses, rent, mortgage payments, utilities, things like that. Temporary possession of personal property. I say temporary because you may not actually be the owner of it, but the court's not going to be able to determine these things at this kind of a hearing, who owns property, who's entitled to it. So they may award it temporarily, but there might be remedies or procedures for the other person to seek the return of it. They can and will often order professional counseling and prohibition against weapon possession. This is not an exhaustive list. Obviously, there are many, many other forms of relief, including the payment of legal fees, any kind of counseling, any kind of parenting skills, anger management. Whether or not you're going to likely have a continuing relationship with this individual, like if you do or don't have children that you may or may not have any reason to have future contact, you may still want to require professional counseling or anger management. One, for two reasons. One, so that the person gets help and doesn't do this to another person. But it will also be relevant later if that person is seeking to dissolve this order of protection against you. If the court has ordered certain types of counseling and the person has not complied, then it's a compelling reason to deny that kind of a request. So what are some of the consequences if you find yourself as a defendant in a temporary and final restraining order? First is if the restraining order is entered, and let's be clear, it is not a criminal matter, but in some cases it's considered what's called a quasi-criminal, which means it's family matter, but it has and can have criminal consequences. So first, your name gets entered in a central registry throughout the state. I don't believe it goes beyond the state of New Jersey, but it is throughout the state. The purpose of that is so that wherever you may go, the police in that jurisdiction and the courts in that jurisdiction are able to find out if you have a order of protection. For instance, if you get an order in Essex County on a Friday and you go down to Camden County on a Sunday, you may not have your papers with you, which I'll mention in a moment that you should, but the central registry allows you to know that wherever you go, they're going to have a record of that. There can be suspensions or revocations of professional licenses, depending on the nature of the allegation and the reasons for the domestic violence. It can and is causing a greater increase in difficulties retaining and maintaining your certain jobs or obtaining jobs. They are starting to ask about this. It is becoming a more significant issue just because you may not have a criminal matter. Domestic violence does obviously suggest, for lack of better words, a character flaw that a lot of employers are seeking to weed out. You will be fingerprinted. Again, it goes part of the central registry so that they can compare individuals if there's violations in the future. You'll be prohibited from possessing weapons regardless of who you are. So, for instance, if you're a police officer and your livelihood is based on your ability to carry a firearm, you will probably forfeit that. I have had cases where I represented police officers where I got them to be permitted to carry their weapons during work hours, but it's rare. And if you're the victim, I would usually recommend vehemently opposing that, despite the fact that I help some individuals. But I think those cases did warrant the need, and there was obviously need for significant support issues. And then the criminal penalties for violating it. This is important because while the final order is a family court order, if it's violated, it's prosecuted as a criminal matter. So it becomes state versus whoever the defendant is. And up until recently, any violation, no matter how de minimis it may have been, is a criminal violation. So if you send a text to a person at a temporary order against you saying, I'm really sorry, that was a violation, and it is a violation. It should be considered a violation, and it would be prosecuted for that reason. There's case law is recently starting to come off of that a little bit because the judges are starting to realize that some people just make mistakes, and that while it's not healthy for the victim and unfortunate, it doesn't necessarily mean that that person should be prosecuted for it either. So now there are many resources. I listed just a few here. Almost every county will have several different um, shelters and resources available. Like I said, there's county statewide programs for emergency shelter, medical attention, legal advocacy, food, clothing programs, all kinds. If you are in a relationship that is of a violent nature and you're currently not in a restraining order or not immediately seeking one, I would start to research the programs that are available to you so that you sort of have a plan available. I know a lot of programs will say, for instance, keep a change of clothes in your car and things like that, keep some extra money. So in case you do need to flee for your safety, that you are prepared. That's kind of based on your individual situations, but you should at least be available or advised of what resources are available around you. There's in Newark, there's a baby family violence program that can give you assistance to let you know what programs are available for you and as well as your family. The Safe House is just that. It's a shelter in Bloomfield. I believe it's in Claramas Hospital. The phone number's there for you. Rachel Coalition, Jewish Family Services, obviously helps all people, not simply just Jewish families. And then there's the Suckler National Council of Jewish Women with the phone number and the web address for that. There's also, I didn't list it here because I haven't had much involvement recently, but there's also the Violent Crimes Compensation Board, which allows you to seek financial compensation from the board, from this organization, if you are a victim of domestic violence, to help you pay for medical bills, legal bills, housing costs that you may have incurred that possibly if either the perpetrator was not of sufficient means where the court could order them to pay the sort of restitution or the support needs that you had. The VCCB, the Violent Crimes Compensation Board, often has money compensation awarded to help you offset these costs. So it's a really great organization that really provides a lot of people that have been not only emotionally and physically victimized, but financially, it helps them out of this kind of a situation. Circumstances to dissolve a restraining order. Remember I was saying before that while they call it final, there are certain circumstances. The lead case that discusses this is Carfugno versus Carfugno, and the citation is up there. And this was a case, it sets forth, and I listed here in detail, the things that the court will look at. Now, not all of these are going to be required issues, but these are what the court should be looking at, whether or not the victim consents, the victim's fear of the defendant. Now, this is an important aspect because while it says the victim's fear of the defendant, it has to be what the court considers to be a reasonable, not a reasonable degree, like a reasonable person objectively would fear the defendant. So it's not, unfortunately, just that you still continue to fear this individual, but that a person under your circumstances, in your circumstances, would feel the same way. The nature of the present relationship, so that would be like if there's any contact or children, whether you're married or going through a divorce. Convictions for violating the final restraining order, the criminal matter I discussed before, whether or not there has been or are multiple. Continuing involvement with drugs or alcohol, which is why I said earlier that it's sometimes good to ask for counseling and assessments. Defendant's participation in counseling. So again, if it was ordered and they didn't participate, it helps protect you. The age and health of the defendant, good faith in opposing it, which goes back to the reasonable fear that you have. Whether or not the defendant has other protection orders in different jurisdictions, and then the catch-all that you generally find in most statutes saying that any other factors deemed relevant. I'm not a big fan of this case. I don't see the point of having a statute that says you get a final order and then a case that says, but for good reason, you can dismiss it. And basically, the Carfugno case says, for good reason, the court can, or for good cause, the court can dissolve it. These are factors the court should consider, but it only needs to find good cause for dissolving it. So I think they need some work in this aspect. I've seen a lot of people who use this as a way to perpetrate domestic violence when they're prohibited from doing it because of a restraining order. So they file motions every 6 months. If there's children involved, they go to a parenting coordinator and they use that as a mechanism to continue to harass and exert control. So you really need to be careful when you're asking for the relief that's granted to contemplate the issues you're going to have in the future, as well as um, how to build in protections for that. So let's take the last few minutes to look at some practical issues. First, as I mentioned before, there's a presumption of sole custody when you get a restraining order. And the law says basically that's for two reasons. One is you obviously aren't going to be able to communicate if there's a restraining order in place. And two, you're not in equal position to be communicating. If you have a disagreement with an abuser, obviously they exert more influence in decisions. So decisions aren't deemed to be in children's best interest made that way. So they presume that you should have sole custody. But in my experience, most judges actually resist granting this. They'll grant you custody, but rarely will they grant and put the word sole in there, even when you ask for it. And even when you tell the court that, it's presumed to be in the child's best interest. Courts are reluctant to grant sole custody because they believe that a child benefits from having both parents involved as much as possible in the child's life. Now, I don't see having sole custody as keeping the other parent from not being involved, but that's the sort of general current philosophy. So you really have to stress this point. And it's an important point because, again, custody issues are a way for an abuser to exert control. So getting sole custody would be very, very important. Custody issues, again, custody practical issues, you do have to figure out how you're going to handle custody issues. Whether you have sole custody or not, there's going to be a need to have some mechanism of communication. Some people choose to have none, absolutely none, and then they have to deal with it, but it usually is harder on the family and the children. Less restrictive alternatives is to have a restraining order that allows for email or text communication regarding the children. You can even further restrict that by having text or emails about emergencies regarding the children, so it's clear what types of communications are and are not permitted. Problems you're going to run into, I mean, I could go on for days and days of possible problems. The first, as I mentioned earlier, the delay. You will be told you're getting an order in 10 days or a hearing in 10 days, and it may be 30 days. And this is for both sides. You may be the defendant in one, rightly or wrongfully a defendant in some, and you're going to be denied parenting time with your children. Routinely, their temporary restraining orders give physical custody to the victim, and they more often than not eliminate all parenting time until the return date. Now, if it's 30, 40 days later, you're looking at a month and a half, you're not having any contact with your children. That can be very devastating to a parent, and it can be harmful to a child. Problems you're going to have on holidays. Like I said, the law exists because police were reluctant to get involved in the first place. More often than not, holidays are times that more acts of domestic violence occur, but you're going to find a lot of opposition by the police when you go and say on Christmas Eve at midnight that you need to get the judge on the phone. But this is your right and this is your need to be protected. They absolutely have to do it. There's something else on that. I'm sorry, I missed it. And then your court appearance. Well, communication, obviously, you have to determine whether or not there's going to be need to communicate in the future. And if there's any need, it may be short-term or long-term. Even if you don't have children, you may find yourself having to dissolve a relationship. You may need to divide personal property. You can, and this goes for custody issues too. You can always agree to have a third person who is appointed to handle those communications. Obviously, you want to take somebody who's favorable to you so you have good protection as well as a good witness. And then the court appearance, a number of issues come. First of all, if you're the victim, you're going to be uncomfortable going to court. You may be afraid that you're actually going to run into the person when you get there. The courthouses keep both the plaintiff and defendant on a restraining order separate before and in the courthouse. But so when you get to the courthouse, tell the court officer at the metal detectors what you're there for. They'll direct you where to go. If you go into court or in the courthouse and you see the individual who is the defendant, go immediately to either one of the courtrooms or to one of the police officers you see and just explain it why you're there and ask for an escort. If the defendant does anything towards you, says anything, gestures towards you, you should go and immediately file that as a violation because it is a violation. Not just simply by that person being there, but if that person speaks to you or gestures to you or says anything, it's clearly a violation and it needs to be reported because it's a serious violation. If they're going to violate it in the courthouse, it's important. that's pretty much the end of it. Here is my contact information for those that may not have it. If you want to take a second just to jot it down, should also all have my email address from registering, so you can get any questions to me. And then I'm going to see if there's any questions. Um, I know a lot of people that are here, many of them signed on late, so I'm sorry if you missed something. I will email you a copy of this recorded so that you can listen to the portions that you missed. Does anybody have any questions before we sign off tonight? I got as much time as you need. Yeah, by the way, I'm sorry if I didn't. You want to type it into the question box under your control panel, and I believe, although I'm unfortunately not certain, I believe the questions are not seen by anybody else. So feel free to write in whatever you need. All right, I'm not seeing any questions. I'm going to check into the chat pane to see if I'm missing anything. Again, like I said, I'm here as long as you need. If there's any questions, obviously you can ask them here. You can also call or email me separately. But not seeing any, I'm going to thank you for coming. I'm going to sign off. And then I'll, like I said, when I see everything's formatted, um, I will email you the version so that you have this as a resource. All right, so thank you for coming. Have a good night, everybody.